Hey guys, Chicago injury lawyer Scott DeSalvo here, and in today's video the topic is, if they're fighting us on the injury case, should we give up? Does it mean we're going to lose? Does it mean they know something that we don't know? So this may or may not surprise you, but the answer is of course not. So first I want to tell you about, over the course of the years I have had dozens of cases where, if you watch some of my other videos or you understand how these cases go, some lawyers get a case and they immediately file a lawsuit. I do that in workers' comp because there's no downside to it. But in third-party cases, I usually wait until you're better and we order your medical records and bills, and I try to settle your case before we file a lawsuit. And there's a lot of really good reasons for doing that. I don't know why lawyers on third-party cases like a car crash, dog bite, fall down case, construction injury, motorcycle, bicycle accident, I don't know why those guys sign the cases and file a lawsuit right away. I think it's a mistake. I think it's a missed opportunity. Sometimes it doesn't make sense to file to try to settle the case, but usually it's a better move because it gets money into the injured person's pocket faster with less disruption to their life, right? But anyway, to each their own. That's the way I do it. Sorry, just merging into traffic. So, you're familiar with that stuff. Sorry, I just have people who are not cooperating with or don't understand how to merge on an expressway. So I've got to keep my head on a swivel here a little bit. Just as an aside, I'll tell you, sometimes I get a message from somebody about how dangerous it is to record video while driving a car, but you'll notice I never mess with the video controls, the audio controls, or even look at the phone. I glance up to look at my rear view mirror and it looks like I'm looking at the camera, but my eyes are on the road the whole time. So I could have a fly on my cheek and I can't see it until after I'm done recording the video. So I do it as safely as possible. It's no more dangerous than talking on a telephone. In fact, I'd say it's safer than talking to it on a telephone because I don't have to think. I don't have to listen to what somebody else is saying, process the response, right? I'm just telling you, I'm explaining a topic to you. But anyway, I've had several cases that were in settlement position where the insurance adjusters tell me, oh, well, we have a statement from your client, or we have photos, or we have black box data from the car, or we've got this, or we've got other medical, or our doctor already looked at it and they think it's a fraud case, or whatever. And I'm going to tell you, I don't listen to that. It concerned me when I was a younger lawyer, but I've had these guys lie to me pre-lit, during the settlement phase before we file a lawsuit. Now, there's no discovery, so I can't make them give those things to me before we file a lawsuit. So I have to take them at their word. And my point is, pre-lit, if they don't give them to us, like if they have bad photos or a statement where you said something that hurts the case, or they have a doctor's report that, makes the case really hard to win, and they don't want to produce it to me, then okay, but how am I supposed to take it seriously if you won't show it to me? And the reason is, they could be lying. So that's the first reason why, if they're fighting the case and you don't know why, remember, insurance companies just want to save money. They want to deny claims, delay paying claims, pay as little as possible. And unfortunately, if there's some insurance companies and insurance adjusters out there who think nothing of BSing you in the negotiation process, right? And they do it usually only do it on the telephone. They won't put it in writing, but a lot of my negotiations for my clients occur on the telephone, right? and I'm not recording it. Presumably, they're not recording it either without notice. But anyway, that's the first thing I wanted to tell you. Just because they're fighting the case and telling us they have evidence, unless they show us the evidence, it could all just be a trick, right? And I've learned to ignore it, right? But here's another one. I recently went to a binding arbitration. Pardon me, my allergies are going crazy today. I recently went to a binding arbitration on a case that is, directly relevant to what we're talking about today, which is the second thing I wanted to talk to you about. And I've had this happen before too. It's not a case without its challenges, right? So in the case I took to arbitration, my guy had a back injury in the past that he was completely open about, admitted he was having problems with it, had an old neck injury, completely honest about it, was still having problems, but he was doing pretty well, around the time of our accident, has the accident, but he was under the active care of doctors for his neck and back before our accident, at the time of our accident. So, that's not, pardon me, it's not like the perfect situation going into it. And then there were some other issues with the case, right? And for the longest time, I was trying to settle the case for the guy, right? And they finally came up with a $1,500 offer. Now understand, this guy had, over $10,000 in medical bills. He had like $30,000 in medical bills and a lot of treatment, right? And he also had a lot of time off work it was right in the medical records. The time off work was ordered by the doctors. Pardon me. So the case had some value, and around and around and around we went, and they made us wait and fight for the $1,500, not $15,000, 1500, 1,500, which was a ridiculous offer, even on a case with some issues, some things that needed to be explained. That's that was the situation, right? So my client asked me, he's like, oh, well, they're fighting it really hard. Why would they be fighting it? My memory's not that good, but I really can't think of any reason why they would be mad at me or why they would not want to be reasonable. I don't want to have to give a deposition and answer all of these questions under oath, do all this written discovery, and what if I messed up? What if there's something that we don't know about? And I told him, I'm like, buddy, listen, with the offer they're making right now, I have your case completely put together. This is the advantage of the way my office does it, okay? We put your entire case together before we even go into suit. So in 99% of my cases, we are ready to go to war from day one. And I do it that way on purpose, because I need to know the strengths and the challenges in your case before I can tell you whether a settlement offer is reasonable or not, right? Some guys do it where they get the medical, they don't even look very carefully at the medical, and if there's an offer, they jump at it and they settle it and they give you the money, and they hope that you'll take the money. It's an easier way to do it, but it's not the right way to do it. But anyway, I told him, look, at this offer, I have so much work put into the file. You've already given your statement. You've already, I've already answered all of these written questions under oath, and I've produced all this evidence to them at this point. I'd rather just go to hearing. So an arbitration is like a mini trial. So it's usually over in about 3 hours. Sometimes it goes longer if there's a lot of witnesses. And it's usually heard in front of a panel of 1 judge or 3 judges. And it's it's often active attorneys who are handling the case, or retired attorneys, or even sometimes retired judges. So it's not like a settlement conference or a mediation, where if the numbers aren't right for either them or us, anyone can terminate it, and we proceed to trial. A binding arbitration is where you have that judge, and you're presenting that case in front of the judge, without a jury, and whatever this judge decides is what you have to live with, right? That's the kind of case. This is one that we couldn't go to a judge and jury anyway, which was fine. That the client was fine with it, and in this case, I was fine with it too. So, I had the client come in, and we prepped, and I told him the trick questions the defense was going to ask, and I'll be honest, I get a little crazy heading into arbitration or trial. I prepped all weekend. I reread everything in the file, and then it was on a Tuesday, and I worked it happened to be on a week when my staff was on vacation, so I was pretty much at the office completely by myself that week. So I went in early, and I did pretty much everyone's job on Monday, and had a really long, hectic day. Came home, went to sleep at like 9:30 because I was so tired. Got up at 11:30, and then worked on this case from 11:30 till 3:30 in the morning. Took a nap from 3:30 to 6. Got up and went into the office at 6. Finished prepping, and then the client came in, and we prepped for a few hours, and then we went to the hearing. We did the hearing for 3 hours. So needless to say, by the end of that day, I was very, very tired. But I was glad that we put all that effort into it. Why? Because it's common before a hearing like this to talk to your opponent to see what authority they have. Usually they call me, but because I was so busy, I reached out to them, and I talked to the attorney, and they withdrew the offer. So going into the arbitration, that $1,500, they took it off the table. And that's something you should be aware of. They'll take money off the table on a case where, they think they're going to smoke us, right? They think we're going to go to hearing, and they're just going to beat the living hell out of us. Well, that didn't happen. Why? Because I prepped, and I anticipated every argument that they could make, and addressed it before the defense attorney was allowed to say a word. And you could hear it in his opening statement. He didn't have anything to say. And during his examination of my client, he asked some questions, but he didn't really have anything to say. And in his closing argument, he didn't have anything to say. And here's what he did say in his closing argument. After offering zero, like the hour before the hearing, no offer at all, he changed his mind to say, under no circumstances pay more than $40,000. So, I don't know if it's coming across, but in the course of the 3-hour hearing, the defense attorney went from no offer at all to saying that he deserves $40,000. Now, I asked for a lot more than that, and we got basically everything I asked for. So it was worth it. My point is, going to hearing on a case like that, doing it the right way, does take a tremendous amount of legal knowledge, legal skill, and effort, right? There are many things that I can do strategically on an injury case that doesn't burn a lot of calories, or something I can have other people help me with, right? But when it comes to an arbitration or a trial, you just have to roll up your sleeves and put in the work. And if you're an experienced attorney and you've worked the case up so that in your file you have all of the relevant facts that you need to prepare the case and argue it the right way, you can really have success. So it doesn't matter what position they take, okay? Remember, they're not necessarily going to be the most honest and upfront people. They don't really care. They want to reduce what the injured person gets paid. And they can do that by just dragging everything out, hoping we give up. They can do it by telling us that they have evidence that doesn't exist, or any of the other dozen tricks that insurance companies use, right? One in like fall down cases or dog bite cases that I've seen insurance companies do is at the beginning of a case, we send notice to the person who's got a claim against them, and we ask them to go notify their insurance company. Well, in a lot of cases they do that, and then the insurance company and the defendant, the person the claim is against, ignores everything. They ignore our mail, they ignore our phone calls, they won't tell us who their insurance company is, and a lot of lawyers give up. A lot of inexperienced injury lawyers will say, well, in this kind of case, there's no way for me to tell if there's insurance or not unless they cooperate, and I don't want to spend the time and money to file a lawsuit to roll the dice, right? Now, I get that if it's a teeny tiny little case, but, you know, that's a topic for another video. But anyway, my point is, I talked to a couple of attorney friends of mine. We meet regularly to talk about my cases, their cases. They give me ideas, I give them ideas. And I told a couple of different attorneys about the case, and they said, man, you're crazy. Like, that's a tough case. You know, you did everything you could for this guy, but that's a tough case. We had to wait for the result for a little while. And they said, like, that could easily, just based on the facts you're telling us, that could easily be a bad outcome, right? Well, it wasn't a bad outcome. You know, we did very, very well for my guy, and I'm glad I put the effort in. But, you know, I could have just as easily told them, listen, they're fighting us so hard, they're offering nothing on a case that we typically would get a better offer on. There must be something we don't know. You know, the verdict potential of this case is very low. I can't spend the time and effort on something like this. We should just drop the case. Well, I don't like doing that. I don't like doing that because I know that insurance company adjusters are often not quite honest. I also know that they sometimes just make mistakes. Sometimes they make a mistake about how they value your case. Somebody evaluates it and they're working on 6 cases at once, and they are negative about case number 3 and your case number 6, and they take that negativity with them when they evaluate your case. So they make mistakes, they don't want to pay. If they have something they can hang their hat on, that's what they want to argue, and they think they're going to win their case. So, you know, neither here nor there, but that's just how the industry works, and you need to know how the industry works, and you need to know and work with a lawyer who you can trust, who he or she is not just telling you to drop the case or to fight the case, and they're not even familiar with your file, right? It's got to be somebody who can bring the case over the finish line, has been around the block, and knows how to do it, right? I mean, you can be willing to fight and not be any good at it, or not be experienced at it. There's a lot of people out there who are bullies, who like to fight as long as they're bigger and stronger and a better fighter than the people they fight in, and that's the position insurance companies and adjusters and defense attorneys often find themselves in. They're more experienced attorneys, they've got an insurance company behind them, their supervisors are telling them to deny claims and screw people around, right? That's why I tell people, if you're in a situation where you've had an injury and you have questions, you should get a free consultation. So anyway, I'm going to wrap this video up. If you or anyone you know needs a lawyer, has an injury case, has questions, needs representation, or might need representation, I offer a free consultation anytime, night or day. This phone always gets picked up by people trained by me to get the information I need, and then they immediately forward it to me via email and text. So if I'm awake, I'm going to be calling you back. And the number is 312-500-4500. That's 312-500-4500. If you're not ready to talk to a lawyer, I've got you covered. I have 2 killer tools on my website. People are using them like crazy and they love them. I'm getting a lot of thank yous from people who are using these tools. Links in the description. They're on my website. They're completely free to use. You answer 7 multiple choice questions off the top of your head, and you get customized information about your situation, all without talking to a lawyer. Free and no obligation. Links in the description. One is called the Case Cash Calculator. It tells you what the settlement value of your case is. The other tool is called the Good Case Calculator. It tells you whether you might have a good case or whether you might have a case with some challenges. So, links in the description. You can use them as many times as you want. Share them with friends. They're right there for you. At this point, I've got well over 200 videos on YouTube, on my YouTube channel, that you can check out. Explains every aspect of how injury cases work and goes into some pretty detailed topics as well. So lots of good information there for you. If you enjoy my videos, please subscribe and hit the bell icon so you get notified. And if you enjoy this video, please give it the thumbs up. That'll tell YouTube to show it to more people, and the goal is to help injured people, especially folks who are not represented, understand how all this works so you don't fall into a trap laid for you by the insurance company. And they lay down a lot of traps because people fall into them and they save money. They beat people out of what they could otherwise get in an injury case by doing that. Okay, so check out my videos, subscribe, give it a thumbs up. Finally, if you enjoy my videos, the tools, my book, my DVD, my injury cheat sheet, all the free stuff, free information I give to injured people for free. If you would not mind, if you're a current or former client or somebody who's had a consultation, or even if you just like my videos, if you wouldn't mind giving me a 5-star review on Google, that would really help me out. People really do read those reviews when deciding who to hire as a personal injury lawyer. And after all, that is what I do for a living. So if you wouldn't mind doing that, I put a link in the description. You just go to that web page. It takes you right to the page. You click 5 stars, say a kind word, hit submit. Literally 5 or 10 seconds of effort on your part, but a favor to me that I will always appreciate and will never forget. So if you don't mind doing that, great. If you don't feel comfortable doing it, that's okay too. I still appreciate you watching. Hope you and the family are well, but if God forbid anybody needs help, give me a call, 312-500-4500. Thanks so much. Have a great day. Bye-bye.